Lauren Rafter. She is with the Colorado Poverty Law Project. She's joined with her colleagues Shannon and David, and they will be presenting on renters' rights.
Hello, everyone. We are so excited to be here tonight with you virtually, and we're so thankful to the FACTS for inviting us to share this information. My name is Lauren, and I'm a housing attorney at Colorado Poverty Law Project. And like she said, I am joined by Shannon McKenzie and David Below, my two colleagues. We're here today to go over some information about the eviction process. Oh, next slide, please. I'm going to move pretty quick through these. I apologize in advance. We've got a lot of information. We're here to go over the eviction process, the stages of it, some updates with COVID-19 and different protections that are available, and then the Immigrant Tenant Protection Act. We have about 20 minutes allocated to go through this information, and then 10 minutes at the end for questions. So if you have any questions throughout the presentation, feel free to add them in the chat, and David or Shannon will try to answer them there, or we'll get to them at the end. You can also feel free to write them down and ask your questions verbally at the end. Perfect. Next slide, please. We will start with some information on eviction. So in Colorado, a tenant cannot be evicted from their home without a court order. We have seen that landlords lie to tenants about this in the past and try to tell them verbally that they need to leave, but you should know that it is illegal for a landlord to evict you without a court order. Next slide, please. In order to get that court order, the landlord must go through a process with the court. That's called the Forcible Entry and Detainer process, FED for short. Next slide, please. And you will get these slides at the end so you can review it. And if you need any interpretation support, feel free to let us know. So these tenant protections apply to everyone in Colorado, regardless of their immigration status. And as we'll cover later on, the Immigrant Tenant Protection Act also adds additional protections for those who are immigrants. Thank you. Like I mentioned, a landlord cannot evict a tenant without a court order. So they can't simply lock you out, turn off the heat, the electricity, the water. And if they do that, it's a violation of the tenant's rights, and the landlord could be liable for damages that arise from that. Next slide. A landlord also cannot simply just call the sheriffs to come and evict a tenant, and the sheriff should not move out a tenant without a court order that is valid. So if you are moved out for any reason by the sheriffs without a court order, contact an attorney. You could call our organization and we could help you with some next steps. Next slide. Additionally, a landlord cannot evict or retaliate against a tenant for bringing up a habitability issue. So if you have bugs or mice or your heat isn't working or your water isn't running, they can't evict or retaliate against you for organizing with other tenants in your same complex in order to advocate for yourselves. And they also can't evict or retaliate against you if you are a member of a protected class. So that means they can't retaliate or evict you based upon your disability, your race, your creed, your color, your sex, sexual orientation, marital status, family status, religion, national origin, ancestry, or source of income. Next slide, please. Thank you. So we'll go through the stages of the eviction process. First, the tenant must violate the lease. Then the landlord must provide notice of the lease violation to the tenant. If the issue is not cured or fixed, the landlord would file with the court and the tenant would receive a summons and complaint telling them to appear at court on a certain day. On that day, the tenant either files an answer or agrees to a stipulation with the landlord. And last, there may either be a trial or a judgment entered by the court. There are 3 different types of lease violations that could lead to eviction. The first is if the tenant breaches a material provision of the lease, either a minor violation that's happened multiple times, or a substantial violation, likely something related to criminal activity. The second one is non-payment of rent. And the third is if the lease has ended, but the landlord did not renew the lease and the tenant stays past the day. Thank you. We can move to the next one now. So if the tenant violates the lease, the landlord has to provide written notice of that violation. This notice is called a notice to quit, a demand for rent or possession, or a demand for compliance. It should say that in big capital letters at the top. So keep an eye out for those. For all cases except for, yes, so this should be handed to the tenant or a family member, anyone above the age of 15 in your home. And if that can't be done, if you're not home for some reason, the landlord can leave it on your door, just taped up there. So for all cases, except for a substantial violation, the landlord must give the tenant 10 days notice, telling the tenant what the lease violation is, and that they have 10 days to fix it or to move out. If the tenant pays that amount owed or offers to pay it, or fixes the violation within that time period, those 10 days, the landlord cannot evict you. If the issue is remedied within, or is not remedied within that time period, the landlord can file with the court in order to get an order to evict you. So if the issue is not remedied and the landlord files an eviction case with the court, the tenant will receive a summons and complaint. These documents, similarly, must either be handed to a member of your household, or they must be posted on your door and then subsequently mailed to you. You must receive it at least 7 days before the court date, so you have time to prepare your answer. The summons will tell you what the court date is and what time you need to show up. It is super, super important to go to court on that day at that time, or file an answer by that time and date listed on the summons. And that's called the answer date or the return date. So look for that on the paperwork if you get it. So what should you do if you received a summons and complaint? Our first recommendation would be to call a lawyer. We would recommend starting with Colorado Legal Services. They have a bunch more attorneys than we do. But if they can help you out for any reason, feel free to reach out to us and we'll try to support you in any way we can. And we will get our information out to you, I'm sure, after this. So if you do not file an answer or go to court and sign a stipulation, the court will enter a default judgment against you. That's why it's super important to pay attention to that court date. And after that judgment is entered, the landlord or the judge, will enter a writ of restitution, which allows the sheriffs to come and move you out as soon as 48 hours later. So what does an answer look like? The answer is essentially just a document where the tenant can tell the landlord and the judge why they should not be evicted, and they can also assert any counterclaims that they have. So an attorney can help you figure out and explore what kind of defenses you have and what you can put in that answer. But I'll run through a few different examples just so you get familiar with it. The first is that the notice doesn't have all the required information that it's supposed to, or it wasn't properly served on you. The second is that you attempted to pay the full amount of rent that you owe within that 10 days, but the landlord refused to accept it for some reason. A third option is that you did not violate the lease as the landlord claimed you did. Fourth, a portion of the lease that was violated was not a material provision of the lease, so it wasn't very important. And last, that the landlord has violated the warranty of habitability, so the place you're living isn't safe, and you've followed the law in order to demand compliance, and the landlord hasn't fixed anything for you. So the second option on that return date is a stipulation. A stipulation is essentially an agreement between the tenant and the landlord, which settles the eviction without having a judge decide the outcome. We want to alert you to be really careful in signing these, as landlords can be tricky in what they add in them, and you could give up some of your rights. So it'd be best to get a lawyer to review this ahead of time if you can. You are not required at all to sign a stipulation, though it may feel like it. It's a very stressful morning, and the landlord's attorney may try to pressure you into signing something. Know that you don't have to. And if you don't understand it, you can ask the judge to explain it to you, and they should review it with you. You can always file an answer on that date instead. Awesome. So if you signed a stipulation, the case is essentially over. You follow the agreement and the court isn't involved anymore. If you file an answer, you will get a trial date where you go in front of the judge and get to plead your case. This would be a great time to get an attorney if you haven't already. The trials are typically within days of the answer being filed, within maybe 5 business days or about a week. Though that may change based on backlog with COVID. The courts are kind of full right now. At the trial, the landlord has the burden to prove that you should not be evicted, or that you should be evicted, to the court. And the standard is more likely than not. So the landlord must prove that it is more likely than not that the property is located within the city and county where the action is filed, that the landlord is the owner or the landlord of the property, that they have the right to evict you, that there is a lease agreement between the parties, that you violated the lease, and that they complied with the service requirements of the notice or the demand, and that the tenant is still in possession of the property unlawfully. So if the court finds that the landlord met their burden and proved those 6 things, the court will enter a judgment for possession for the landlord, saying the landlord has a right to the property. And within 48 hours, the court will issue a writ of restitution, which allows the sheriff to move you out, you and your property. So, quick recap. The landlord has to give you notice before an eviction can start. Super important. The landlord also has to get a court order before they can make you move or move your personal belongings out. If you pay your rent or you fix the minor violation within those 10 days, the landlord cannot evict you. If it involves violence or drugs, the landlord may be able to evict you. That might be a substantial violation, but they still must go to court first. Don't miss your return date. It's a super important date. And don't sign a stipulation that you don't understand. If you file an answer by that return date, the court will set a date for trial, usually within 5 business days. Consequences of eviction may be that you could lose a housing voucher, a Section 8 voucher, a FEP voucher, any kind of voucher, or maybe lose eligibility for public housing assistance in the future. And it would also show up on your credit score. So we would like to keep evictions off people's records as much as possible, because those are some pretty negative consequences in getting housing in the future. So what about COVID? Right now, there are 2 different protections that are available temporarily during this pandemic that we're all going through. I don't have them here, but we can send you the CDC order and the executive order so you can read them if you'd like. But the CDC order or CDC moratorium applies to everyone throughout the United States. And it says that if you can assert 5 things that you make under $99,000 a year, that you are using your best efforts to get government assistance to pay your rent, that you're paying as much partial rent as you can, and that if you were to move or to be evicted, you would become homeless or live in shared living spaces. That wouldn't be very healthy with this virus going on. And yep, I think those are the 5 things. So if you meet all of those criteria and you sign a CDC declaration and you give it to your landlord, you cannot be evicted for non-payment of rent until the end of June. We are super excited that that was extended at the end of March. very great protection. So if you are get a notice for eviction for non-payment of rent, and you can fill out the CDC order, we would recommend that you do and give that to your landlord. The second protection is that Governor Polis issued an executive order saying that landlords cannot charge late fees on rent that hasn't been paid. And this goes until the end of April. This has been going on off and on since March of 2020. So if you've been charged late fees for any reason and you think it's unlawful, feel free to let us know and we can see if it was during one of the periods of time when the moratorium was in place for those late fees. And our last topic. We'd like to talk a little bit about the Immigrant Tenant Protection Act. We also have a handout in English and Spanish that we can provide to you all. That's a summary of this. So as I mentioned earlier, immigrant tenants have additional protections under the law. This law went into effect January 1st of 2021, so it's pretty fresh. And it prohibits landlords from discriminating against individuals due to their immigration or citizenship status. Here, I can read through the different things. The first is that landlords cannot demand, request, or collect information regarding your citizenship status or your immigration status. The landlord cannot disclose, if they do know about your citizenship status or immigration status, they cannot disclose or threaten to disclose that information to anyone, any entity, any person, any law enforcement agency. A landlord is prohibited from harassing, intimidating you, or retaliating against you for exercising your rights simply because you are, because of your immigration status or your citizenship status. A landlord is prohibited from interfering with a tenant's rights, including influencing or attempting to influence a tenant to leave the property that they have a right to be at, or to not apply or live at a certain property because of their citizenship status or immigration status. A landlord cannot refuse to enter into a lease agreement with anyone or approve a subtenancy or otherwise stop anyone from occupying a unit because of their immigration status or citizenship status, even if it's just a small part of their reasoning. And a landlord cannot bring an action to recover possession, so an eviction action based solely or in part on someone's immigration status or citizenship status. Whew. So I flew through that. We would love to open it up for questions, generally, hypothetically right now. But if you have any specific legal issues that you want to talk with us about, feel free to attend our monthly legal clinic. We do it via Zoom. It's the third Wednesday of every month from 4 to 6. And we have volunteer attorneys to talk about really any legal issue you may have and help you to figure out some next steps. You also can contact us there at contact@copovertylawproject.org with any individual questions, and we'd be happy to try to help you out.
Wonderful. Thank you so much, Laura. And now we will open it up for some questions. So if you have a question, please, we have a question and answer box that you can click and type in your question, or if you want to raise your hand, Veronica will allow you to ask questions. We'll give it a few seconds to allow individuals to ask questions. And I would like to ask one if possible. Can I? Yes, Lauren?
Please do, yeah.
Okay, all right. So what would happen if someone, all right, they're behind on their rent, for example, let's say April, because we're on April, but then their lease ends in April and they do want to stay at the same location. Can the landlord say, no, we cannot continue this lease because you owe money, even though the tenant is applying for rental assistance through the state?
Yeah, Shannon or David, feel free to jump in too. Unfortunately, it's my understanding that if the lease is ending anyway, the landlord has a right not to renew that if they want to. And that's how we've seen landlords kind of find a loophole through this no eviction for non-payment of rent. But if the lease is like a month-to-month lease, then the landlord has to give certain notice. So they need to give 21 days notice before they can terminate the lease. So if your lease is being terminated or not renewed for any reason, you can still reach out to us and we can assess and see if the landlord has the right to do that or not.
Okay. All right. Thank you so much.
Mhm.
All right. Do we have any other questions in the chat? Nope. All righty. Well, thank you so much for the presentation, Lauren. Really appreciate it. Maybe you can stick around and maybe
I see a question.
there's
What if you can't afford an attorney? So Colorado Legal Services provides attorneys for free, and so do we. So we do not charge you for any of our time, anything that we do. So feel free to give us a call.
Oh, with that, I have a follow-up question with that.
Yeah.
How long does it usually take to get connected with an attorney for issues like this?
It depends on the urgency of the issue. Let's say you call us tomorrow and you have a hearing on Thursday. We will do our best to get you an attorney immediately. If the issue is one that doesn't need to be solved immediately and we have some other eviction cases the next day, it may take a few more days. But we typically try to get back to you within 48 hours to set up an intake. And then if it's a more urgent matter, we can hurry along.
Okay, all right, wonderful. Great. Thank you so much for sharing all that important information with us. Really appreciate it.
Of course. Thank you for having us.
Definitely. All right. So thank you. And